May I request everyone to please settle down? We'll just be starting the session now. So welcome back, everyone. I request the chair of this session and the esteemed speakers to please join me on stage. Can we please have a big round of applause? The theme of this session is Investor-State Dispute Settlement in 2024. This session is being graced by Honorable Mr. Justice V. Ramasubramanian. Justice Ramasubramanian enrolled as a member of the bar in 1983. He practiced for about 23 years in the High Court of Madras. He was appointed as a permanent judge in 2009. He was sworn in as the Chief Justice of Himachal Pradesh High Court in 2019 and appointed as a judge of the Supreme Court of India on September 23rd, 2019. We welcome you, sir. With him, we have our esteemed speakers. Ashwita. Ashwita is a legal counsel at the Permanent Court of Arbitration. As legal counsel, she acts as registrar and tribunal secretary in international arbitrations involving various combinations of states, state entities, international organizations, and private parties, including arbitration proceedings under investment treaties. She is also a co-registrar of the Mauritius International Arbitration Center. We welcome you. We also have with us Mr. Amit Sibal. He's a renowned senior advocate appearing regularly at the Supreme Court of India, the Delhi High Court, and various high courts and tribunals across the country. He's ranked as a leading practitioner for dispute resolution by Chambers and Partners Asia Pacific Guide. Mr. Sibal accepts engagements as counsel and arbitrator, as frequently engaged as an expert witness in international commercial arbitrations. We welcome you, sir. We also have with us Mr. Kenneth Beale. Mr. Beale is an international litigation and arbitration partner at Jenner and Block and brings more than 15 years of experience for client-facing complex international disputes in diverse range of jurisdictions, including against foreign governments. His practice includes first chairing and representing clients in numerous commercial and investment state arbitrations before the world's leading institutions such as ICC, LCI, etc. We also have with us Ms. Jhangiani, who's recognized as a leader in international disputes and has been recognized as one of the top 15 female lawyers in Asia by the Asia Legal Business. She's a barrister in England and Wales, as well as a solicitor and advocate of the Supreme Court of Singapore. Along with her counsel work, she sits as an arbitrator and a mediator. She's also the chair of CIARB Singapore, vice chair of the ICC Commission on Arbitration and ADR, and an editor of Investor State Law Guide. With this, may I now request the chair to please take the discussion forward.
A very good evening to all of you. It's always good to start a session on time. If that is not possible, it's good to wind up a session on time. We are supposed to wind up this session at 5:40, I suppose. I don't know. I have absolutely no control over the time at which the session started, but I can exercise some amount of control over the time at which we will wind up, because that is the privilege the chairman has got. But I would not cut into the time that is allotted to each of the speakers, because they have all, I saw, we assembled about 3:45 or so. All of them were preparing as if they were preparing for an examination. In fact, if an examination is held on ISDS today, they will all come out with flying colors. So I would cut short my introductory remarks to a few minutes so that the floor is open to the speakers who have prepared so well. And I also believe in one thing which they wanted me to tell you. The less you speak, the less you expose yourself. I believe that mouth is the window through which one can see that the top floor is empty. So the more you keep the window closed, the more advantage is it's for you. By way of introductory remarks, I would only say three things to begin with. All of you know that the convention on investment settlement disputes entered into force in about 57 years ago. So the topic for the discussion today is ISDS in 2024. I think the catchwords in this session are in 2024. Where are we in 2024? In January 2024, in Miami, there was an arbitration week held. The famous French arbitrator and the former president of the International ICC Court made a few interesting observations on where we are in 2024. What he said was, the arbitration community is losing the fight to ensure the survival of ISDS, endangering the future of commercial arbitration in the process. He further said that built over 40 years on a framework of over 3,000 multilateral and bilateral treaties, the ISDS system is in crisis because we, the defenders of the idea, have been politically defeated. He said, we have lost the battle of public opinion and to a large extent, the battle of legitimacy. This is what he said just a month ago. Two cases. I'll tell you what happened in two interesting cases and then give the mic to the other speakers. I don't know how many of you have heard about this Prospera versus Honduras. See, Prospera is a US company. They established in the year 2021 what is called a charter city in a special economic zone in Honduras under a local law called ISDS law, Special Economic Zone Law of Honduras. These SEZs, Special Economic Zones, are quasi-sovereign private governance zones where companies can operate almost independently of the government. The criminal law of the country alone will apply to the Special Economic Zone, to the charter cities, but the civil law, labor law, etc., can be framed by these companies themselves. This is because such an idea was floated by the former president of, the former chief economist of the World Bank, Mr. Paul Romer, who said poor countries could grow rich by encouraging foreign-run charter cities. When Prospera was established in 2021, it was actually celebrated as a crypto-libertarian paradise. But this ZED law, ZA law, actually was passed in the year 2011, it was declared unconstitutional by the Supreme Court. The government changed the composition of the Supreme Court, reenacted the law by a constitutional amendment. That is how Prospera could enter Honduras. Eventually, what happened was in 2012, there was a huge public outcry because no law of the country would apply to a charter city within this country. This outcry resulted in the government of Honduras repealing ISDS law. Then BIT, arbitration, was launched by Prospera, where $11 billion in damages were awarded against Honduras. And according to reports, this $11 billion was equivalent to nearly 2/3 of Honduras' entire 2022 budget. Atlantic described Prospera, this company, as a neo-medieval and neo-colonial undertaking. Bloomberg described it as a mini startup nation with its own set of laws. Eventually, what happened was 30 US senators sent a representation to the US trade representative requesting him to intervene in the matter to save the Republic of Honduras from going bankrupt. This is one case. The second case is one where the commercial court in London has come down very heavily upon what is happening in the arbitration field. The Global Arbitration Review has carried an article dated 23/10/2023 titled "The Most Severe Abuses of the Arbitral Process." According to this report, the Commercial Court in London on 22/10/2023 overturned an arbitral award against Nigeria on the ground that the award was procured through false evidence, corrupt payments, and improper retention of leaked documents. The contract was backed by the claimant company in that case by bribing an official. The official was silenced during arbitration process. Leaked documents were used, and a huge award was secured. Interestingly, I do not know how many of you are lawyers sitting here. The Commercial Court in London, Robin Knowles, came down heavily upon two law firms who advised the claimant company. One law firm had charged $850 million. The other law firm had charged $3 billion. Therefore, the court set aside the award on several grounds. One of the arguments advanced by Nigeria was their own counsel had taken bribes. So this is where we all stand. I wish I was part of that law firm. Anyway, we are not lucky, and none of you is lucky to be part of such a law firm. For triggering this discussion, we have formulated certain subtopics. Mr. Amit Sibal wanted to talk about this UNCITRAL Working Group 3's reforms. And also he wanted to touch upon India's BIT model 2015 and India's, going back on 70 out of 80 BITs. Then Ms. Ashwita wanted to talk about code of conduct for arbitrators. I was, in a very lighter vein, I was telling her that under the General Clauses Act, conduct includes misconduct. Therefore, she may even talk about code of conduct or misconduct of arbitrators. Then Ms. Sapna may talk about the mediation in ISDS. And Mr. Kenneth would like to talk about climate change. I was telling him that Delhi is currently undergoing a climate change. Therefore, it would be appropriate that he will wind up the session with, or Ms. Sapna will wind up the session with mediation. So with these few introductory remarks, I will now call upon Mr. Amit Sibal to initiate the dialogue. Thank you.
Very good evening to all of you. Thank you so much, Justice Ramasubramanian, for that introduction. And if I can just say, following up on your metaphor of keeping the mouth closed to save the top floor, they also say the eyes are the window to the soul. So if you want to save your soul, you have to keep your eyes closed as well. And I hope not too many of the audience this evening, given it's a long day, will follow this advice and keep their eyes and mouth shut. I must say that as I've been reading material on ISDS and BIT over the last few days, I find a lot of wordplay on BIT, bilateral investment treaties, bit player, once bitten, twice shy, and so on. So I thought I would have my own wordplay. The line that kept coming to mind was iambic pentameter in Hamlet. "'Tis bitter cold and I am sick at heart." And I'm sure that Shakespeare was not referring to BITs when he said that, but the line does reflect, to some extent, the disenchantment with the BIT system that is also reflected in the two examples that Justice Ramasubramanian just gave from the podium. And India actually is at the forefront, if I may say so, of that disenchantment. India entered into 79 bilateral investment treaties between 1994 and 2010. From 2011 to 2024, India entered into just 4 of them in comparison. And after 2011, of the ones it had already entered into, India actually terminated 76 out of 87. Net result of these numbers is today, India has only 8 BITs remaining in force. And India is not alone in this. You have South Africa, you have Brazil, Ecuador, who have all but withdrawn from the, I'll call it the old order of the ISDS system. So let me try to briefly explain why this has happened. And let me start with what ISDS really is. So BITs, bilateral investment treaties, are agreements between countries for reciprocal promotion and protection of investment by investors from one country in the other country. How do they achieve that? In order to protect that investment, they contain standards of treatment, including for expropriation, direct or indirect. And the idea is to provide a safer and more predictable environment to attract that investment. And they all have a dispute resolution clause, and that's where ISDS comes in, and that is what we call Investor-State Dispute Settlement Clause, which allows, and this is peculiar to this system, an investor in one of the signatory countries to directly bring a claim against the other signatory country for failure to adhere to the standard of treatment that is contained in the BIT and claim compensation. So that being the background, what's the problem? Well, the problem arises with, and the first debate really, is about what the standard of treatment should be. And that is what I will call the substantive problem. In most BITs of the kind that India entered into from 1994 to 2010, and indeed in 78% of the BITs entered into from 1959 to 2016, there is a clause called the FET, Fair and Equitable Treatment, and that's all it says. It gives you no normative guidance as to what is the limit on discretion of an ad hoc arbitral tribunal that will interpret that clause. And so it is open to the tribunal to decide in a particular set of facts that something constitutes failure to have fair and equitable treatment. That is one aspect of the debate. The other aspect is the MFN, or Most Favored Nation Clause, which is again something that, well, you negotiate a treaty, you negotiate particular provisions, but if you have an MFN clause, then you're obligated to give at least as favorable treatment to the contracting state as you've given to any third-party state. And both of these have come to bite, or they have bitten India in various claims that have come out of BITs that India has signed, and I'll come to that shortly. But I must point out that while there has been a backlash from India and others, in India at the forefront, India has not withdrawn completely. I would say that it would be accurate to say that India is really reimagining its place, as Justice Ramasubramanian put it. In 2024, India is really in the throes of reimagining its place in the ISDS firmament. It is currently negotiating in the 14th round with the UK as to what the FTA should say, and some of the clauses that I referred to are sticking points in that negotiation. February 1st of this year, Finance Minister announced clearly and unequivocally that India does intend to enter into bilateral investment treaties to attract foreign investment. So that is the stand, and that doesn't reflect a complete disengagement from the system. Now, there's also a set of structural problems that I'll briefly touch upon, other than the substantive clauses. And that is, you can imagine that in the peculiar circumstances of BITs, how you can have inconsistency in arbitral awards. Because if a state takes one action, a policy decision, say, it affects 10 different investments. Each of the 10 investors sets up and invokes 10 different arbitral tribunals. Each of the 10 arbitral tribunals may come to a different interpretation of what is fair and equitable treatment in those circumstances. And you frequently, therefore, have vastly inconsistent awards, which creates inconsistency and chaos. And that's a structural problem that, again, is causing what Justice referred to as a crisis of legitimacy, as spoken of at Miami. And so a specific example of that happened in Argentina, where Argentina undertook an economic measure which affected economic value of US investments in Argentina. There were 5 tribunals. 3 said that the measure was defensible on grounds of emergency measures for necessity, and 2 said no, it was indefensible. On exactly the same set of facts, there were completely different outcomes among 5 different tribunals. There is lack of transparency, which is important, because ultimately, if there is a compensation that is granted pursuant to a claim, it's a bill that the taxpayer has to pay, and the taxpayer has no visibility as to what is happening in a private 3-member tribunal on grounds of confidentiality. There is a fear of regulatory chill in countries like Honduras, in that example. Inability of states to regulate critical areas like public health, environment, taxation, and labor for fear of claims being brought by private investors under BIT. Damages awarded by ISDS tribunals can be as large as in the examples that were given by the chairperson. So these really are the areas of debate. And if we look at how India has reacted to that debate as a mini case study, we can look at, for example, India, after terminating 79 of its BITs, came out with a model BIT of 2016, where it essentially did 3 things, and I'll highlight those 3. 1, it jettisoned the blanket FET and said, look, we will have a nuanced protection of investment provision to replace it, to say that, well, we will say that no party shall subject investments made by investors of the other party to measures which constitute a violation of customary international law through denial of justice in any judicial or administrative proceedings, or fundamental breach of due process, or targeted discrimination on manifestly unjustified grounds such as gender, race, or religious belief, or manifestly abusive treatment such as coercion, duress, and harassment. Now, the reason I'm quoting this is that you'll notice the use of the particular adjectives, fundamental, targeted, manifestly, conveying a message that the standard of review of governmental conduct should be more deferential than before, and the threshold for finding a violation should be higher than before. But I think it's a positive step, and something that, for example, has not been a matter of great controversy in the negotiations that India is having. So perhaps a kind of middle path. But it's also interesting and not surprising that India has made clear that taxation measures of the state can no longer be challenged before the ISDS tribunal, which is a direct response to the Vodafone arbitration, where retrospective taxation was a ground to hold violation of the BIT, as also in the Cairn Energy cases. The second aspect is the MFN clause, which has been completely done away with in the model BIT. And this is a reaction to the White Industries case, where the India-Australia BIT contained no provision that made it an obligation to have effective means to assert claims and enforce rights. But based on the India-Kuwait BIT, the arbitral tribunal got around that and said that a delay of 9 years in enforcing by the private investor of an award against Coal India constituted a breach of the provision in the India-Kuwait BIT, which was then brought in through the MFN clause, and India was asked to pay up $4.08 million back in 2010, and which triggered a reaction, a backlash, as many have called it, from India. Thirdly, we have what we call the exhaustion of local remedies, and slightly controversially, I might say that this is probably the least defensible of the limbs of the model BIT, where the stipulation is that you cannot invoke arbitration under the BIT, under ISDS, until you first exhaust local remedies in India for 5 whole years. And you must approach administrative and judicial authorities in the country and do your best there. And in the meantime, you might suffer further losses. And thanks to the whittled down FET, you might not recover for those losses, but you have to do that before you come to arbitration. Not surprisingly, that's been a sticking point in the current negotiations with the UK. The Law Commission, in fact, recommended in its 260th report that this provision be done away with and there be an immediate ability to go to arbitration, but that has not been accepted so far. There's also a problem that I can briefly touch upon of enforcement, because the view taken so far is that in Delhi High Court included and Calcutta High Court, is that really there is the claims that arise from a bilateral investment treaty are a matter of public international law and therefore don't arise from a commercial relationship, and therefore under the New York Convention cannot be enforced under the Indian Arbitration Act 1996. Now, the logical result of that being that if you do have an award as a private investor pursuant to a BIT, then it's not a decree, it's not a judgment. And at best, you'll have to file a suit, and it will be of evidentiary value in the suit. And if the idea is to provide certainty and enforceability, then that's a problem that would have to be addressed. And interestingly, it has been sought to be addressed in the model BIT by providing expressly that a claim that is submitted to arbitration under this article shall be considered to arise out of a commercial relationship or transaction for purposes of Article 1 of the New York Convention, which is clearly an attempt to plug that loophole. I won't spend much time on the multilateral investment court because there's a clear signal that we should try to finish on time. But I will mention that there is a strong push from the EU to replace ad hoc arbitration in BIT with a multilateral investment court, to say there should be judicially trained persons who are part of a court, who follow precedent. There should be an appellate procedure. It should be more transparent. And this should address, according to them, a lot of the structural problems that I indicated in the current system. We'll see how that goes. In the negotiations with India, they are making that a precondition to move further, and that's been a problem. But at the end of the day, the old order changeth. Yielding place to new, whether that happens or not, we'll have to see. Certainly, capital exporters have to realize in this day and age that countries are no longer, and in the global south especially, are no longer willing to accept the same blanket FET and MFN without setting any conditions of their own. It's no longer the case that they're going to sit back and like Honduras did. And I believe in that case it was just the Attorney General on his own defending it with no experience. They're not going to sit back. In my own experience, they will They will hire expensive counsel outside India to defend themselves in BIT and win. And that's what's happened in the latest BIT, which India did win, where a claim was made based on a blanket FET provision. And there are really many instances, and India is a good example, whereas compared to 20 years ago, these countries are themselves capital exporters as well. And they are much more attractive as markets today than they ever were, with high growth rates and burgeoning markets for foreign investment. So if you take too hard a line with them, well, they might not actually comply and enter into a treaty with you. But at the same time, capital importers have to realize that if the finance minister is saying that we want to have bilateral investment treaties, we need them to attract foreign investment, then of course, there has to be a meeting of the minds and both sides have to soften their stance. There are statistics, there are studies that have said, and I can quote one, Simon Hartman and Roxbrook, that when India terminated 44 unilateral BITs between 2013 and 2019, there was a dip of 30% in the inflow of FDI. But I must tell you that there is other material in the public domain which suggests that there isn't an appreciable impact. I think it's hard to judge, and so that's why I started with what the government stand is publicly, because we'll go by that. We'll say there is an intent to enter into it, and if there is that intent, then I think there should be a process of constructive engagement to yield where it makes sense, and I think both sides have to realize that in the spirit of constructive discussion. Now, whether it's going to be a case of old order change it, yielding place to new, or plus ça change, time will tell. Thank you.
Thank you, Amit, for providing a very interesting, landscape of this ISDS regime. In fact, the life is full of paradoxes, and the world of trade and commerce is no exception. One of the grounds on which several countries oppose this BIT is that the ISDS clauses tend to be more favorable to developed nations. But look at what developed nations do. United States is opposing ISDS. European Union says that any clause in the Energy Charter Treaty is incompatible with European Union law, therefore we will not go by that. So several arbitral tribunals have been giving contradictory awards as to whether these clauses are binding or not. So on the one hand, somebody says it leans in favor of developed countries. On the other hand, we have developed countries themselves opposing it. We don't know where we really stand. With this remark, I'll now call upon Ms. Ashwita to talk about a code of conduct for arbitrators. People who want to be arbitrators, please don't listen to it.
Thank you very much, Justice Ramasubramanian. And I would encourage arbitrators to please listen to the discussions about the code of conduct. My name is Ashwita. I work at the Permanent Court of Arbitration. The PCA is also the host, the proud host of this panel. So I would like to start by thanking the distinguished chair, as well as the panelists, for taking the time to be a part of this discussion, as well as the organizers of Delhi Arbitration Weekend, particularly Shashank, for getting us involved and giving us this platform to host this panel today. I thought I'd also start by discussing perhaps why it is that we chose ISDS in 2024 as a topic for this session. Needless to say, the PCA is involved in the administration of a number of disputes that arise out of multilateral and bilateral investment treaties. We have to date administered approximately 330 ISDS claims, and of the 210 cases that we're administering today, approximately half are ISDS cases. So it's really a core area of our work, and an area that we're following very closely given how dynamic the space is right now. And we thought it would be of particular interest to this group because, well, first off, as Mr. Sibal eloquently put it, India is undergoing a reimagination of its approach to investor-state arbitration, but also because of the cases that the PCA has administered, a number of them do involve Indian parties. So the PCA has to date administered 44 cases that involve Indian parties, both on the respondent and the claimant side. So India is also a big user, or Indian parties are a big user of the international investment dispute settlement practice. So hopefully the discussions today will be interesting for many of you. My presentation this afternoon will cover one of the topics of discussion that have arisen in the context of the reform efforts of the ISDS space, which is the publication of a code of conduct for arbitrators in international investment disputes. I'm going to start by providing some background and also sort of the developments that led to the code being published. I'm then going to focus on 5 key provisions of the code, just in the interest of time. I've picked the 5 that I find most interesting, which I hope you agree with me about. And finally, I'll briefly consider the responses to the code to date and what we can expect going forward. Now, this particular session of the Delhi Arbitration Weekend has had a number of conversations and panels that have discussed bias, independence and impartiality, and ethics in the context of arbitration. And so it comes as no surprise that this matter of ethics and a code of conduct for arbitrators in ISDS was raised in a multilateral forum. In 2015, the state of Algeria, in an ancestral setting, raised the question of whether it would make sense for there to be a unified code for arbitrators in international investment disputes to follow. And the reason for this was because there are, in fact, a variety of sources that could bind or guide arbitrators when they are in an international dispute, and it would have been helpful for there to be some clear guidance on which standards would necessarily prevail amongst those competing standards. And the Ancestral Secretariat therefore requested the states that were sitting in the ancestral discussions to discuss whether there is in fact a need for a harmonized authoritative source on ethics in international arbitration. As many of you know, and as Mr. Sibal also alluded to in the course of his discussions, in around 2017, Ancestral did entrust Working Group 3 with a broad mandate, and it was to work on the possible reform of investor-state dispute settlement and to develop relevant solutions. And as part of the various concerns that were identified with the ISDS system, one of the issues that was identified was a perceived or apparent lack of independence and impartiality of some arbitrators in ISDS tribunals. And they identified that this often gave rise to criticism about the legitimacy of the ISDS system. It was proposed in response to this identified concern that establishing and promulgating clear obligations that would, of course, lie upon arbitrators, could be one of the solutions to the identified concerns, provided that they touch on topics such as independence and impartiality, limitations on multiple roles that arbitrators can play within the ISDS system, confidentiality, and disclosure. And these are all ideas that we've heard a lot about in the course of this week. The events leading to the adoption were really that Working Group 3 and ICSID decided to work together on the Code of Conduct as a joint project. The starting point for the preparation of this code was really a review of all of the existing codes of conduct or standards that either were published by institutions or were generally in use in the context of international arbitration. And drafting the Code of Conduct was then a very iterative process. There was a first draft published, I believe, in March 2020, and then there was a consultation period that followed that involved comments from various stakeholders. All the drafts were published, and there were formal invitations for stakeholders to provide their thoughts on various provisions. The draft then went through 4 further iterations when finally in May 2023, a final version was published, which was then adopted by Ancestral at its next session. And then it was in December 2023, so quite recently, that the UN General Assembly approved the final text of this Code of Conduct. Now, this brings me to what exactly are the key provisions in this Code of Conduct. The first key provision, in my view, is that the code contains a familiar affirmation that arbitrators in these disputes must be independent and impartial. And this is, of course, not something that's unusual in different rules that you might have seen. But what I thought was interesting is that it also goes one step further, and it sets out non-exhaustive lists of behavior which might actually suggest a lack of independence or impartiality. And there's a long list, but what it does include, notably, is taking action that creates the appearance of a lack of independence and impartiality. And reading this ties into what I think was a key point of discussion in yesterday's inaugural session, where the speakers spoke about how it's quite difficult actually to establish actual bias, and therefore in some situations demonstrating an appearance of bias might be enough to impugn a particular arbitrator. So this, the code sort of lines up with that thinking on this particular subject. Second, and this is perhaps the main and most controversial innovation of the code, is that it attempts to regulate the practice of what is known colloquially in the industry as double hatting. Now, many of you already know what double hatting is, but just for completeness, I'll set out that double hatting generally refers to the practice of an individual sitting typically as counsel and arbitrator in different international investment arbitration proceedings. And why is this a problem? It's a problem because it opens the possibility of that particular individual making rulings in their capacity as arbitrator that could then benefit them in their actions as counsel. And there are many divided thoughts about this. One school of thought is that this is problematic because it raises questions about the neutrality of arbitrators in ISDS proceedings. But there are others who are more sympathetic to this practice. And they say that having that experience as counsel actually affords arbitrators a more well-rounded perspective and gives them better skills to act as arbitrators in other cases. And they also note that excessive regulation actually dissuades younger arbitrators who may have active counsel practices from entering the arbitration industry. So it may actually be an obstacle to diversity if one was to come down very hard on double hatting. Naturally, this was very controversial in the context of multilateral discussions on how this should be regulated. And one of the early versions of the code actually imposed a complete prohibition on double hatting. This particular stance was then watered down a little bit, and what we see in the final version of the code is actually sort of a compromise provision that prohibits arbitrators from acting as counsel or as experts in certain situations. Firstly, arbitrators cannot serve as counsel concurrently in proceedings that involve the same measure or the same or related parties or the provisions of the same treaty or contract. So there is a prohibition on concurrently acting on matters that in substance or in terms of the parties involved can have a direct influence on another matter. But second, there's also a prohibition on arbitrators serving as counsel for a period of 3 years after they have acted as an arbitrator in a dispute that involves a particular measure or a certain party, and a prohibition in a period of 1 year on arbitrators acting as counsel on proceedings involving the same measures under the treaty or the same treaty or contract. So there is, the same provisions in the treaty or contract. So there's some aspect of this that's simultaneous. So certain concurrent actions are prohibited, but there's also sort of a delayed onset of that prohibition as well to prevent future actions that are relatively close in time to when you've just acted as arbitrator. It's worth noting that parties may agree in each of these situations to waive these requirements, so it's not an absolute prohibition, but the starting point is that there is some degree of regulation on the practice of double hatting. The third area of the code that I found particularly interesting is that it tackles or regulates the use of tribunal assistance in investment arbitration. There was a growing concern about the transparency in the use of assistance, as well as some concerns that decision-making was being delegated to assistants who were meant to help the tribunal and not actually act in their stead. In order to address these concerns, first, the code makes it clear that parties should just not be consulted, but they must agree to the terms of the appointment of any particular assistant that the tribunal may wish to engage. And they must also agree on the role and the scope of their duties, so what they will be doing in the proceedings. The code also makes it clear that arbitrators cannot delegate their decision-making function to anyone. They've obviously been appointed in order to resolve the dispute, and that role should not be performed by someone who hasn't been appointed to do so. A fourth point that I found interesting was a regulation of ex parte correspondence. The code regulates pre-appointment interviews between arbitrator candidates and parties, and this was really to regulate concerns that had arisen about whether party appointments actually resulted in the appointment of independent and impartial arbitrators. In the prior session, the Honorable Justice Rao highlighted some problems that might arise with direct appointments of arbitrators if they aren't actually approached in advance about their availability. And it might just be that these arbitrators have conflicts of interest, or they're not available, or they cannot act for other reasons. And so it's obviously necessary for there to be some amount of contact ahead of the appointment to see whether the particular arbitrator is able to take on the appointment. And the code therefore comes up with a good compromise solution. They say that it says the pre-appointment interviews by parties when they're making appointments are permitted, but they must be limited to discussions on availability, experience, skills, and conflicts of interest, and cannot stray into matters that actually touch upon the substance of the dispute, for example, procedural issues or matters relating to jurisdiction or the merits of the case. The fifth and final point that I wanted to cover is the fact that the code is more prescriptive than one would see in other rules of procedure on what kind of disclosures should be made by arbitral tribunals or arbitrators when they're appointed, and on a continuing basis. The code indicates that arbitrators should disclose not just financial and business relationships with parties in counsel or any interest that they may have in the outcome of the dispute, but also all other proceedings, all other ISDS proceedings that they are currently sitting in or have been involved with in the past 5 years is either arbitrator or counsel or expert witness, so that's quite a broad disclosure requirement, as well as any appointment as arbitrator or counsel by a disputing party in the past 5 years, so even outside the ISDS context, and that's really to address a very specific concern that was raised about arbitrators receiving repeat appointments by the same party in different matters. What's interesting also is that in the context of disclosures, the code makes it clear that there could be other standards that are relevant to assessing whether a disclosure should be made or not, particularly the IBA guidelines on conflicts of interest in arbitration that are widely used. And I thought that was interesting because it shows that one of the concerns was obviously fragmentation, and there was this idea that you wanted to bring together different standards, and the code seems to do this by drawing in standards from different that have already existed in the industry. The response to the code has been mixed. There are individuals and commentators who think that the code doesn't go far enough because ultimately the code is not binding. It doesn't have an enforcement mechanism. It's a set of standards that parties can choose to apply to their cases or not. And ultimately, the code doesn't actually have a mechanism by which you can challenge arbitrators. The idea is really that it sets out the standard that parties can then use and apply in the context of challenge proceedings under the rules that they've agreed, the arbitration rules they've agreed. So there isn't really also a monitoring mechanism. There were discussions when the code was being drafted that there should be an institution or perhaps an advisory center that comes out of the Working Group 3 process that monitors and generates sanctions for arbitrators who violate this code. But there's none of that here, and that has upset some people who think that the code hasn't gone far enough. There are also some interesting points raised about whether there's the right balance between party autonomy and addressing the concerns about the system, largely because, for example, with double hatting, parties are able to waive all of those rules. And the question really is, should the parties be allowed to do that if the concern was really a systemic concern? So who is really the audience for all of these reform efforts? Is it the users? Is it the system, whatever that is? So interesting questions there. But of course, on the other hand, there are commentators who think that the code goes too far because the disclosure obligations are in fact quite detailed and go further than what one might see in other standards or rules. And there is some concern that arbitrators are being asked to share a lot of information. But overall, there's a lot of recognition that the legitimacy of this effort derives from extensive, transparent, multilateral consultation. And there is a sense that there will be a positive role that this will have on assuaging concerns about the lack of independence and impartiality of arbitrators. More importantly, this code is actually the first instrument that's been approved that's come out of the Working Group 3 process. So there is a little bit of optimism given that it's been finalized about other things that might emerge out of the Working Group 3 process. So in conclusion, we'll have to wait and see whether parties use these particular set of rules that are in the code. And also, we have to also see how exactly this fits into the other reform efforts that are being discussed at Working Group 3, which are not yet final and still are sort of moving around. So, yeah, it's sort of a work in progress. Thank you.
Thank you, Ashwita. A quick reflection. See, she talked about double hatting. In an article titled Revolving Doors, Malcolm Langford provided an empirical analysis on the prevalence of double hatting. The article states that in 509 of the examined cases, 47%, at least one of the appointed arbitrators was simultaneously acting as legal counsel in at least one other ISDS proceeding. Therefore, in the case of FREIF, Eurowin Holdings versus Spain, the arbitrator's appointment was successfully challenged on the ground that he rendered a dissenting opinion against Spain in yet another case and advised another party against Spain. So perceived bias, etc., was put into place. So thank you very much for highlighting all this. I now call upon Mr. Kenneth to talk about ISDS and climate change.
Thank you. So a little over a week ago, I woke up in the morning, and before I went downstairs to have my cup of coffee and my breakfast, I did what I say I won't do, and that is I picked up my phone to check my emails. And I saw that, I know approximately how many emails I get in the morning, and there were far more emails that day than normal. So my heart sank, and I thought, what's happening? Is there a crisis at the office? Something going on with the firm? Is there a personal issue? And I opened my emails, and what was the cause of these extra emails was the fact that the United Kingdom had withdrawn from the Energy Charter Treaty a little over a week ago. Now, I have acted as counsel in a number of investor-state arbitrations, and I've spent much, if not most, of my career in the United Kingdom. So there were a number of requests for comment. There were press inquiries. Can you give us a quote on this? And there were also reactions from colleagues and friends of mine to this development. And it was interesting to read the reactions. Some of the reactions were along the lines of some of the phrases that we have heard today. This is awful. There's clearly a crisis of legitimacy going on with ISDS. There's a disenchantment, and we don't understand why. This is terrible. This is a victory for Vladimir Putin. Those of you that know, Russia was the first state to withdraw from the Energy Charter Treaty a long time ago. This is a victory for Donald Trump, for those opposed to multilateralism who are, nationalists and anti-globalist. And then other friends of mine responded by saying, isn't this amazing? This is such great news. Finally, some sense is coming to the investor-state dispute settlement process. This is wonderful for all of us that practice in this area. And these are, reasonable and rational people on both sides of the debate. So I'd like to talk a little bit about how we got here to this point. And to do that, I'm going to back up to COP21, almost 10 years ago, and then talk about what has happened since then, such that investor-state dispute settlement, which during COP was seen as this very green, wonderful thing, is now seen as the enemy of climate change, to the extent that some people seem to think that if you support ISDS, you're going to increase climate change by 2 or 3 degrees Celsius above the COP levels. And then I'll touch on what has happened with the Energy Charter Treaty and finally, tell you what I think is really happening here. And just to foreshadow on what I think is really happening here, I think climate change is a battleground now for a proxy war between those who favor ISDS and those who oppose it, often having nothing to do with climate change. And secondly, those who oppose are winning, because there's an interesting alliance happening right now between those who are genuinely concerned about climate change and those who really don't care about climate change. I come from a country where a lot of people don't believe in climate change, but they're still opposed to ISDS, and they're joining this movement. And I'll try to do all this in about 7 or 8 minutes so that we finish on time and can move to the next speaker. So let's go back in time to 2015, to COP21. So I was in Paris for COP21, and there was this incredible energy and excitement in the air that finally almost 200 nations were coming together to limit increases in global warming to 1.5 degrees Celsius or less above pre-industrial levels. There was a sense of cooperation and multilateralism in the air. It was very exciting. There had just been an IBA report, their Task Force on Climate Change and Human Rights, that had been released. And if any of you were in Paris at the time, there was a side event to coincide with COP at the ICC's headquarters on Avenue President Wilson. And this was sort of a celebratory side event by practitioners of international arbitration, talking about how green we are and how wonderful international arbitration is and how it's part of the solution to climate change. And I think that the thesis there was international arbitration would be a wonderful thing to help solve climate change issues in at least 3 or 4 respects. First, there was discussion about the fact that the COP21 goals were not binding on the parties to the agreement. So there was a lot of discussion of Should they be binding? And if so, how would you enforce their binding nature? And of course, we arbitration practitioners thought we, of course, are the answer to that. Number two, there was a lot of discussion about ISDS and how this was going to drive foreign direct investment in green technologies. In order to meet the COP21 goals, countries would have to invest and get help from outside of their borders in low carbon, low emission technologies. Public investment wasn't going to be enough, and ISDS would lubricate this and make it happen. And third, there was a lot of discussion about how international arbitration generally was going to be used to solve climate disputes. And shout out to the PCA, which had one of the original sets of rules and regulations on arbitrating climate-related and natural resources-related disputes. They're great regulations. They have some very good arbitrators and experts qualified to handle those disputes. So there was this celebratory multilateral atmosphere. Environmentalists arbitration practitioners sort of wrapped them up themselves up in green flags and were very proud of what they were going to do in the years to follow. If I had told them now that I'd be sitting here in 2024 having the discussion that we're having, most of the people there just absolutely wouldn't believe it. So how did we get from there to here? Well, there have been a number of recent reports that have been issued that give you an idea of where current thinking is on this issue. So the United Nations recently issued a report. And if you have any doubt of the author's positions, you just need to read the title and you can figure it out. The report is titled, "The Catastrophic Consequences of ISDS for Climate, the Environment, and Human Rights." UNCTAD has also released several notes on this issue, and the overall tenor of them is there is an absolute opposition between being green and stopping climate change and ISDS on the other hand. There have been, pointed out that sort of all of the things that are seen as good in ISDS can be bad for climate change. National treatment and MFN clauses can lead to situations where if there is incentives for low emission investors that are not given to high emission investors, they could run afoul of those provisions. FET provisions have been invoked in a number of cases where coal-fired energy has been phased out. Countries that try to expropriate oil plants, for instance, and oil production facilities have been alleged to have violated ISDS agreements. So, the general tenor of the debate is that, to use the language of UNCTAD, ISDS poses a major challenge to climate change initiatives, has a chilling effect on governments' willingness to regulate and to meet their COP21 goals, and it is, quote, essential to immediately reform ISDS if we want to tackle climate change. So now, I thought I was green in 2015. Now I'm apparently the enemy of climate change. And look, there are a number of cases that have led people to this conclusion. Some of you may know there's the RWE and Uniper cases against the Netherlands, where two German companies brought treaty claims against the Netherlands because the Netherlands, in order to meet their COP21 Paris Agreement goals, agreed to phase out coal-based energy, and the German company said, "Oh, violation, you owe us billions of dollars under investment treaties." And I have a list here. In the interest of time, I'm not going to go through them. If you want to look at a list, go to that UN report that I told you about. They have an annex with a number of cases that they think are offending. Now, is this a real problem? It's a little bit hard to say. Statistics are kind of vague and not great in this area. I think it's clear that a number of cases have been brought alleging that environmental regulations violate investor-state treaty protections. It's less clear how successful those cases have been. Governments have won a number of those cases, although they have lost some of those cases as well. There have also been cases going the other way. A Canadian company in Allard versus Barbados, for instance, an ecotourism business in Barbados, alleged that Barbados destroyed the value of their investment by not taking enough environmental regulations, not having good enough environmental regulations. Is this a real issue or not? It's hard to say, but it's having real effects. So one real effect is with respect to withdrawal from the Energy Charter Treaty, and the other, apropos of what Amit was saying about the India model bit, is that bits are being torn up right and left, and they're being replaced by new and slightly strange bits that have, let's say, limiting language in them. So let me say just a few quick words about the Energy Charter Treaty. The Energy Charter Treaty was created in 1994. I remember that as well. I was at the time living in Russia, working for the US government. And again, there was sort of great multilateralism in the air. And the purpose of the Energy Charter Treaty largely was to make Western companies that wanted to invest in the former Soviet energy sector comfortable that they could do so without having their investments expropriated or otherwise taken over. Now, the Energy Charter Treaty has been discussed in a number of different ways in a number of different forums. Generally, the criticisms of it are the ones that I have mentioned earlier, that it unnecessarily and inappropriately fetters states' ability to regulate for climate change. And what you have seen recently is numerous countries withdraw from the Energy Charter Treaty. Germany, France, the Netherlands, Poland, Ireland, Luxembourg, Slovenia, Spain, Denmark, Portugal, all have withdrawn from the Energy Charter Treaty. And the UK announced that they were withdrawing from the treaty just over a week ago. And let me just quickly read two quotes. One is from the conservative Tory party net zero minister, who said, "The Energy Charter Treaty is outdated and in urgent need of reform. Remaining a member would not support our transition to cleaner, cheaper energy and could penalize us for our world-leading efforts to deliver net zero." The Labour Party shadow minister agreed, rare to have political agreement, and said, "We are in an urgent global fight against the climate emergency. We've long argued that the Energy Charter Treaty is not fit for purpose, and it's good the government has finally taken these steps." In the US, you've got the Donald Trump Make America Great guys, and you've got, Biden and the Democrats. They can't agree about anything except this. They both hate ISDS. So all of these countries are now out of the Energy Charter Treaty. There was an attempt to reform it and redraft it to exclude fossil fuel investments, to reduce its sunset clause, and to make it palatable. In a nutshell, there were 15 rounds of negotiations, and ultimately it appears that that didn't seem to work. So my question here is, what is going on? And you see this also with what Amit was speaking about, where countries are ripping up their BITs and trying to replace them with BITs that have all sorts of caveats and conditions to them that, for instance, in the climate change space, carve out regulations on the environment from the treaty protections. So what is going on here? Is this about climate change? And the answer, I think, is yes and no. There is no doubt that there are people who are very concerned about climate change, who see current ISDS protections as a threat to government regulation. Whether their views are defensible and supportable is another story. But they definitely exist, and they are concerned, and they are organized, and they have the loudest voice in this debate. There's another group of people, however, that just hate ISDS. And they've been around for a long time. And they hate it for all the reasons that you've heard. It's secretive. It harms poor countries. It's a bunch of old white men who sit around who are super pro-business in their closed rooms while they smoke their cigars and come up with these terrible awards and so on. And there was right now as we speak, there's floating around a petition. Some of you may have seen it if you're on the Ojamid listserv that made the rounds there last week, somewhat controversially. It's a petition with signatories like Joseph Stiglitz, who is a Nobel Prize-winning American economist, Lawrence Tribe, those of you that are American constitutional law fans will know him. And the petition uses very harsh language about ISDS being effectively, the devil's work, and it's terrible, and we need to get rid of it. totally get rid of investor-state arbitration. They never talk about climate change. That's not their concern. They just dislike ISDS. And in fact, I know a number of people, and I mentioned this earlier, who are anti-ISDS in the US, who do not believe in climate change. They believe that climate change is a hoax like COVID and other things, but they are still anti-ISDS. And there's this strange marriage here between the climate change activists and the anti-ISDS activists that is leading to success in this area. So where do we go from here? Well, look, my immediate takeaways are things are changing. More governments are going to rip up their treaties. You're going to see treaties more like the Indian model, BIT. India was ahead of its time. It was at the vanguard in some ways. I think those sorts of model treaties are going to become more common, maybe without the 5-year exhaustion of local remedies point. Whether they're going to be signed by the thousands is another question. But if I was advising states, I would tell them to rip up their treaties, that they should do that. And states that are on the receiving end of claims in this area, I think tribunals are more receptive than they ever have been to defenses on the basis of environmental regulations. For investors, you got to be really careful and do your treaty due diligence when you're structuring investments. Know the treaty atmosphere of your host countries. Think about this very hard, and if you care about this issue, you need to speak up, because the train has left the station and it's moving in the opposite direction very, very quickly. I think the bottom line is we're entering a new world and a new phase nobody would have guessed in 2015 at COP21. Whether this will achieve the climate change aims that the supporters of this approach say remains to be seen, but it's happening, and I don't think there's any turning back now.
Thank you, Mr. Kenneth. Before you said the train has left, the audience has not left. So you were talking about two very strong groups airing extremely opposite views. In fact, United Nations in Citral comes up with a lot of reforms. But the same United Nations publishes a report titled Playing Polluters, the catastrophic consequences of investor-state dispute settlement for climate and environmental action human rights. What it says is, billion-dollar ISDS claims are becoming routine in climate and environmental cases, representing a gold mine for foreign investors and an economic nightmare for low and middle income states. This is another report of the United Nations. It says the interests of elite foreign investors are prioritized over domestic investors, the state, human rights, a healthy environment, including a safe climate, and local communities that are affected by active and proposed projects. Therefore, the war is between investment climate and nature's climate. Thank you so much. Now I call upon the last speaker of the day, Ms. Sapna, on probably mediation and ISDS. Middle path is always safe. Therefore, we have chosen mediation as the last.
Thank you very much indeed. Can I say, firstly, what a privilege it is to be on this panel. Thank you very much to the PCA for inviting me. Thank you to the organisers of Delhi Arbitration Weekend. And I say that even though I find myself in the unenviable position of being the last speaker at the end of a very long day. And I note that the time for our session has actually already expired. I feel a bit like a substitute brought on in overtime, and I've got to really prove my contribution to the manager, but I will do my best, and I'll do my best to keep it really short. Should just say, obviously, any of the views I share are very much my own personal views. I'm not speaking on behalf of the Attorney General's Chambers of Singapore. Okay, so where are we now? What's the state of play ISDS 2024? There is no doubt that there is dissatisfaction with the current state of the system, in particularly from states. Some might say we're at an inflection point. And there are two streams of thought and work flowing from this. Firstly, we have the improvements to the current system. So we have states, with India really being in a leading position here, trying to narrowly define the contours of what investor-state dispute settlement is going to look like where India is involved. We have improved ethical standards for arbitrators come up with by Working Group 3 and ICSID, as Ashwita talked about. There are other innovations. We've got new ICSID arbitration rules, new ICSID mediation rules. We've actually got, just picking up on the Honduras case, which our chair mentioned. Our chair mentioned that the Attorney General of Honduras essentially fought that case alone. One of the discussions currently before UNCITRAL Working Group 3 is a setting up of an advisory centre to really help capacity building, information sharing, the appointment of external counsel for investor-state arbitration to make sure that particularly developing states who find themselves at the end of an investor-state arbitration without the necessary expertise have resources. And I think that the discussions on that for a draft statute for an advisory centre are going to be picked up by Working Group 3 in April. So we've got that first bucket of ideas, improvement to the current system. Secondly, we've got discussions about changing the whole system. We've got a multilateral investment court, which the EU is pushing for and which Amit mentioned. I want to come back to the idea of reforming the whole system and actually end with that. But first, I'm going to talk about mediation. Now, I'm not sure what stream mediation falls into. Certainly, the current context in which it's discussed is mediating investor-state arbitration in the form in which we have it. But whatever form investor-state dispute settlement takes in the future, there's always going to be room for mediation. Those of us who mediate, we see ourselves as peacemakers. There is always room for peace. Even in the sphere of interstate disputes, which I don't have time to talk about. Anybody wants to chat about that, maybe after this session. But we live in a fractured world. There is more room for peace than ever. So there's a lot of enthusiasm for mediation at the moment. We have lots of instruments. We have instruments from ICSID. We have UNCITRAL rules. Working Group 3 has come up with guidelines, provisions. We have all this enthusiasm, but not much take-up. Why is that? There's a few reasons. I'll just touch on 3 briefly. The first is accountability. The second is that the context of mediation in investor-state arbitration at the moment is too premature. We see it mentioned in the cooling off periods before arbitration has started. A dispute isn't ripe then. We often see claims overstated at that stage of proceedings. Of course, you can't have mediation too late, but I think currently the context in which we're seeing mediation is it's just too premature. And the third final key challenge, which I'll end with, is that the outcome of the dispute may have an environmental or social impact on civil society. It's going to affect many stakeholders. I should mention, some people say that the increased involvement of litigation funders in investor-state arbitration is preventing settlement. My personal experience is I don't agree with that at all. Having worked with funders on several occasions looking at arbitrations and enforcement of awards against states and state-owned entities, it's key for funders to actually get cash in return for our investment. And they tend to be very alive to the risks in investor-state arbitration, and more importantly, the risks of enforcing against states. And we have a plethora of cases and jurisprudence on that at the moment. So they tend to actually be very commercial, very willing to take a haircut in a settlement and investor-state arbitration. Okay, so looking at the 3 challenges. Number 1, key challenge, accountability. Whoever decides to settle a claim on behalf of a state without a formal legal determination could later be criticised, possibly by a subsequent government. We've called this bureaucratic indecision. Essentially, you don't make a decision, you just kick the can down the road and you wait until you've got an adjudication. There are solutions to this. One example is the solution adopted by Egypt. they set up an interministerial committee to deal with investor-state dispute settlement, and settlement agreements with investors only become effective once approved by the Cabinet of Ministers. So that's one option. A related issue to accountability is this tension between transparency and confidentiality. We have a move towards increased transparency in investor-state arbitration. I think we've got 2013 UNTRA rules on transparency in treaty-based disputes. But that's in conflict with the fact with the mediation, everything takes place behind closed doors. You don't know what documents are being produced, you don't know what's being discussed. But there are solutions. Working Group 3 suggests that what states can do is in certain treaties providing for mediation, a provision that the mediation proceedings and all documents related to the proceedings are confidential, but the existence of the mediation and the settlement outcome are not. So there are solutions to this accountability problem that we have. Secondly, the prematurity of current mediation proceedings. We need more dexterity in how mediation is employed and how it intersects with ongoing proceedings. What we really need is more creativity. One option is to have a standing mediator appointed at the beginning of proceedings. They will be at standby and they can step in and mediate at an appropriate point in the proceedings. They can either mediate the whole dispute or specific issues in the dispute. You can have mediation alongside the arbitration process without the arbitration proceedings being stayed. So there's lots of options. What we need is intentionality and thoughtfulness. And one of the things that Working Group 3 has done to help this process, it's come up with various provisions talking about how mediation can be deployed, emphasizing that it can be deployed at any stage in proceedings. Now, I should mention, I had the pleasure of hosting a discussion with Professor Gabrielle Gaufman-Koller last year in Singapore, specifically on the mediation of investor-state disputes. Now, she's a leading arbitrator in the field, and she said she's had many cases in which she has sat as chair or co-arbitrator, in which she really wanted to suggest to the parties that they should settle. She mentioned one case in particular where a project had been abandoned, terminated. It was clear that it could be resuscitated to the benefit of both the state and the investor, but she felt that she couldn't propose that they go away, have a chat and settle, perhaps even mediate. We don't have a culture where arbitrators do this. The culture in commercial mediation is changing. Arbitrators are saying in case management conferences, have you thought about mediation? Do you want to have a window for mediation where we stay the arbitration proceedings? We need to see this cultural change in investor-state arbitration. And I think Professor Kaufman-Koller actually may lead the charge in this regard. She mentioned that what she's going to do is put in the procedural order number 1 that the arbitrator can discuss the possibility of settlement with the parties, not facilitate the settlement, but have the conversation, ask them if they've thought about mediation. Now, Professor Kaufman-Koller's procedural order number 1 is actually model procedural order number 1 on the ICSID website. So maybe we'll see this cultural change. Okay, the last thing I want to talk about, my final point. One of the challenges to mediation is the social impact of investor-state arbitration, which touches on what Kenneth has been speaking about. Now, in November 2023, Toby Landau gave the Chartered Institute of Arbitrators Alexander Lecture, which is available online on YouTube. If there is one takeaway you take from what my thought sharing today, it's that if you're interested remotely in investor-state arbitration, you must watch this lecture. Now, this lecture was delivered 2 weeks after the UN report about the catastrophic impact of investor-state arbitration on the environment and climate change. But what Toby was talking about was not the substance of treaty protection that underlies the framework of investor-state arbitration. What he was talking about was the process. He said investor-state arbitration was conceived of as a depoliticized way to deal with investor-state dispute settlement. Take the politics out of it, get some objective standards, and all will be fine. That was over 50 years ago. And an adversarial model of commercial arbitration was adopted. But the scope of investor-state arbitration has got bigger and bigger. We're not talking about commercial investments that have a narrow impact anymore. We're talking about cases that have huge potential environmental, social impacts, potentially affecting a substantial chunk of the GDP of certain countries. Toby's thesis is that the system was never designed for this. It has become necessarily political because the impact of these cases is political and the model is not appropriate. And what he talks about, with very moving examples, is the inflammation and scarring, as he talks it, that has been felt by those members of civil society that are impacted by certain arbitrations. These communities don't have any say in the proceedings. These proceedings are decided in the World Bank in Washington, far, far away from their regional, rural communities. I think he mentioned one in the remote mountainous region of Honduras. What he says is that an inquisitorial approach is needed. We need to recognize that politics plays a part. So 2 points from this, my final points. Firstly, mediation has a role to play in these types of cases. If you give all of those affected a seat at the table, you give them an opportunity to be heard. They may have an opportunity at least to share their views and potentially to contribute to solutions, but you have to give them an opportunity to be heard. Absolutely critical. And the final point is, I do think that we need to give scrutiny to the current system. Even if we talk about replacing it with an investment court, it's still an adversarial system. We might need to go back to basics and look at reforming the model from the roots up, look at an inquisitorial approach. We need to be critically analysing this. In fact, in Singapore on the 8th of April, the Centre of International Law is having a whole day devoted to this topic, following on from the Alexander Lecture. All the developments that we're talking about, some would say, are simply a band-aid. They're just sticking a plaster, and they're actually not going to fix the problem. We can fix the symptoms, but to fix the problem, we may need to change the whole system. Thank you very much.
Thank you, Sapna. Thank you very much. Actually, our session was intended to be for about 90 minutes. We started by about 4:55, and we have wound up with 75 minutes. I must thank my panelists for being on time. And in fact, we are supposed to have a question and answer session at the end. If you have any questions, we will reply by email. And please be rest assured that our replies will not have an attachment of our invoices.
Do we have any questions from the audience, so we can then close the...
Yes, one question. My name is Sushil Shankar, and by some coincidence, just yesterday, I happened to meet Ms. Meg Kenya, the Secretary General of ICSID. And she being from ICSID and me being from India, not surprisingly, one of the things we discussed was why India hadn't ratified ICSID so far. And of course, she was keen that India ratify the convention. But I wasn't sure why India was avoiding it. And so my question for the panel, although Mr. Sibal might be better placed to answer being from India, is this: why hasn't India ratified this? Especially because things have changed, circumstances have changed, and it's not just one way people investing in India, but a lot of Indians, a lot of large Indian companies are also investing outside India. So it might actually be to our advantage also. Thank you.
Thank you for the question. So I'll give a short answer to it. The answer is that traditionally it has been commented that India has not been keen to subscribe to ICSID, mainly for the reason that it takes the enforcement of awards completely outside the system of India's national courts. But on the other hand, it is notable that our courts have taken the view that in any case, BIT awards, as I mentioned, are found to be not amenable to enforcement under the Arbitration Act 1996, and that's the current prevailing view. But you'll notice that in the India Model BIT of 2016, Clause 2.6, if I remember correctly, says, and I quoted it in my remarks, that claims leading to an award under the BIT would be deemed to be claims arising out of a commercial relationship as intended under the New York Convention. And the sequitur would be that would then be enforceable under the system of the Arbitration Act 1996. If that's any indication of what the intent of India is, then the intent at the moment seems to be that awards should still be amenable to enforcement under the Arbitration Act 1996, which would be contrary to the position that would prevail if India were to subscribe to ICSID. But the rest you'll have to ask the finance minister.
Thank you, sir. We'll take one more question if there is any. Else we'll... Yes, please, sir.
Hi, everyone. I'm Ankitesh from AZB & Partners. I have a question to Mr. Sibal. So, sir, one of the issues that arose in the Kane energy arbitration in India was with respect to the interpretation of the FAT clause and the standards to be applied to see whether the FAT clause was violated or not. And the tribunal ended up using the generally accepted principles of international law against what India proposed. So, and this is one issue which arises in almost all treaty-based arbitration disputes. Do you think listing out what would include the violation of FAT clause in an exhaustive manner in the clause itself will solve this problem of interpreting the FAT clause in detail and having detailed arguments on what is the correct interpretation of FAT clause? Because most of the FAT clauses are inclusive in nature. So do you think making it exhaustive will solve this problem?
So, I don't think that any attempt to make it exhaustive can actually succeed. It's not possible to exhaustively list out all the instances where FET clause would be violated. But there is an attempt in the model BIT to narrow it by giving specific instances, though it remains inclusive. There are adjectives used, as I pointed out. But my answer to your question really is that it won't stop lawyers licking their lips and having a field day with interpretation of those very clauses and the meaning of the words that are used in them. So however you slice and dice it and you try to draft it, I do think it's an improvement if you make it narrower, but it won't stop people claiming to have the last word on interpretation.
That's because lawyers also want to have a fair and equitable treatment.
Thank you so much.
So
sir.
with this, thank you all the panelists for such a gripping session. We come to the end of the day filled with learnings and insights. Now may I actually request Honorable Miss Justice Rekha Palli, Honorable Judge, Delhi High Court, member of the Arbitration Committee, Delhi High Court, member of the Organizing Committee, DAW, to please come onto stage to facilitate the speakers. May we have a big round of applause? Thank you all the panelists. Thank you all for this wonderful day, and we'll see you all tomorrow. Thank you.
I know. Yeah. I always pick topics that I find.
Yes, yes.